Hi again, everybody. Sorry I was away last week. I had some medical issues that came up, and they really had to be handled. And so I really apologize for that because I know that there are some people out there who really enjoy my videos, and so in that instance, that's why we're doing this early. I have completely finished notes for the remainder of the Constitution, and so we're going to get in as many of the remaining amendments as we can today. I'm not sure how many, but as you remember last time, we finished the Reconstruction Amendments 13, 14, and 15, which freed the slaves, gave them citizenship, and gave them voting rights. Now, today we start with the 16th Amendment. The Congress shall have the power to lay and collect taxes on incomes from whatever source derived without apportionment among the several states and without regard to any census or enumeration. Basically, 16A allows Congress to levy an income tax without equally dividing it among the states based on population, as it says in Article 1 with the taxation clause. It was passed by Congress in 1909 in response to the 1895 Supreme Court case Pollock versus Farmers Loan and Trust. In that case, SCOTUS ruled that an income tax was a direct tax and should follow the rules of the taxation clause in Article 1. 16A received the necessary approval of states on February 3rd, 1913, and effectively overruled the court's decision. There have been many debates over the years. However, many prominent law professors have agreed that an income tax, although a direct tax, is the only exception to the taxation clause. But there's still many people in the know over the last century who have not given up their fight to prove that 16A violates the principles of the Constitution and should be repealed. I am among those. It won't surprise you, though, that progressives and populists greatly support income tax because they feel tariffs are unfair to the poor and that income taxes would put more burden on the rich. We all know by now that's a pile of crap. So, 17th Amendment, which also came in 1913. The Senate of the United States shall be composed of 2 senators from each state elected by the people thereof for 6 years, and each senator shall have 1 vote. The electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislatures. When vacancies happen in the representation of any state, the executive authority of such state shall issue writs of election to fill such vacancies, provided that the legislature of any state may empower the executive thereof to make temporary appointments until the people fill the vacancies by election as the legislature may direct. This amendment shall not be so construed as to affect the election or term of any senator chosen before it becomes valid as part of the Constitution. 17A changed the method of choosing senators, allowing for popular election and instead of being chosen by state legislatures, and thereby it superseded Article 1, Section 3, Clauses 1 and 2. It changes the procedure for filling vacancies in the Senate, allowing for state legislatures to give their governors power to make temporary appointments until election can be held. It was ratified April 8, 1913, but sitting senators were not affected by the changes brought about in this amendment, so it took a full 6 years to get implemented. There were many advantages to the original method of electing senators. Prior to the Constitution and the Articles of Confederation, the government was a body where the states, for all intents and purposes, had formed nothing more than basically a permanent treaties with each other. Excuse me. And the citizens stayed loyal to their original state. Under the new Constitution, the federal government was given more power than ever before. And election of senators by the states assured the anti-federalists that there would be some sort of protection against the state's powers getting gobbled up by the government, providing a check on the federal government by the states. And also another advantage was the longer terms and lack of popular election. This made the Senate a body within the federal government that could, and quite often did, counter the populist passions of the House of Representatives. And while members of the House were operating on a 2-year direct election cycle, that made them more frequently accountable to their constituents. Senators, on the other hand, could afford to be more detached from the process, and more detached from bills and issues coming through Congress. And theoretically, the state legislatures retain their right to instruct senators to vote how they wanted on proposals, giving the states both direct and indirect representation in Congress. With the Senate and the House responsible to two separate and distinct constituencies, it helped to defeat the problem of the federal government being subject to special interests. You see how that's working nowadays. There were many issues leading to the adoption of 17A. Among those were deadlock in the state legislatures and political corruption. We're going to discuss it a little bit. To some people out there, there was a sense that senatorial elections were being bought and sold. In other words, the Senate seats were changing hands for political favors and money rather than the competence and ability of the person running for the office. Let's see. It was between 1857 and 1900, I believe, that the Senate investigated 3 elections over corruption. For instance, in 1900, William A. Clark had his election voided after the Senate concluded that he had bought votes in the Montana state legislature. However, there's a couple of analysts here, Jay Bybee and Todd Zawicki, who believe that this was a largely unfounded concern, and because of there wasn't a whole lot of hard evidence on the subject, the serious lack of it, and so they just believed that it was not really unfounded, it was really unfounded. And electoral deadlocks, deadlocks in the state legislature were a big issue. Because state legislatures had the power to choose their senators, they had a difficult time deciding. I mean, it relied on their ability to be able to agree, and some states couldn't. I mean, and as a result of that, it delayed sending senators to Congress. And in a few cases, it broke down to the point where states completely lacked representation in the Senate. Deadlocks began to become an issue in the 1850s. For instance, with a deadlocked Indiana legislature allowing a Senate seat to sit vacant for 2 years. Between 1891 and 1905, 46 elections were deadlocked across 20 states. At the time, that was over half of the Senate. In one extreme example, a Senate seat from Delaware went unfilled from 1899 until 1903. And the business of holding senatorial elections also caused disruptions in the state legislatures, with one example being that a full third of the Oregon House of Representatives refused to swear the oath of office in 1897 due to a dispute over an open Senate seat. And the result of that was that Oregon State Legislature could not pass any legislation that year. And Zwicky gives his opinion again on this, and arguing that it was not really a serious issue, as even though deadlocks were a problem, they were an exception rather than the rule. There were many legislatures that did not deadlock at all, and the ones that did deadlock in the 19th century were the newly admitted Western states who really lacked experienced legislatures and weak party discipline. I argue that despite the deadlocks and the supposed corruption, popular election of senators went against the Founding Fathers' intention of the Senate being representative of the states. The problem could have easily been solved if 17A had simply empowered state governors to appoint a senator if the legislature failed to meet a certain deadline. And that appointment would expire once the senator was chosen. It is in this vein that I call for an amendment to repeal 17A and replace it with the changes that I just mentioned, along with safeguards to prevent or curtail corruption. There's been a lot of changes done to our Constitution that go against the Founding Fathers' original intention, and 17A is definitely one of those. As mentioned earlier, senators being elected by the state legislatures left the federal government, the problem of special interest groups were not a problem, really. And now that we have senators elected by the people, special interest groups are getting involved. And we have a lot of problems now. A lot of people just don't see it. There are problems. And now we'll go to the 18th Amendment. I'm sure you've heard about this one. If you haven't, then you're about to. After 1 year from the ratification of this article, the manufacture, sale, or transportation of intoxicating liquors within the importation thereof into, or the exportation thereof from the United States, and all territory subject to the jurisdiction thereof for beverage purposes, is hereby prohibited. The Congress and the several states shall have concurrent power to enforce this article by appropriate legislation. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislatures of the several states as provided in the Constitution within 7 years from the date of the submission hereof to the states by the Congress. Prohibition. 18A basically banned sale, distribution, and manufacture of alcohol in the United States. It was proposed by Congress December 18, 1917, and ratified by the states January 16, 1919. And it was later repealed by the 21st Amendment in 1933, but we'll get to that. It was the product of decades of effort by the temperance movement, which was a group who believed that a ban on the sale of alcohol would help alleviate poverty and other societal issues. And we all know that's a load of garbage. 18A declared, even though it declared that the production, transportation, and sale of intoxicating liquors illegal in the United States, it did not outlaw actual consumption of alcohol. Shortly after it was ratified, though, Congress passed the Volstead Act to provide for the federal enforcement of prohibition. The Volstead Act declared that wine, liquor, and beer all qualified as intoxicating liquors and therefore were prohibited under the auspices of 18A. Also, another section of that, prohibition began January 17, 1920, 1 year after the amendment was ratified. And although it did lead to a decline in alcohol consumption in the United States, pretty much nationwide enforcement of prohibition was very difficult, particularly in cities. You had organized crime syndicates and other groups who were engaging in large-scale bootlegging, and speakeasies were really popular in certain areas. and it didn't take long for public sentiment to turn against prohibition in the 20s. Actually, in 1932, Democratic presidential candidate Franklin Delano Roosevelt called for the repeal of 18A in his platform. Excuse me. Now we'll go to the 19th Amendment. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. Congress shall have the power to enforce this article by appropriate legislation. 19A prohibits state and federal governments from denying voting rights to American citizens because they are women. Initially, it was introduced in 1878. There were several attempts to pass a woman suffrage amendment, but they failed until 1919, when suffragists pretty much pressed President Woodrow Wilson to call a special session of Congress. On May 21st, 1919, the proposed amendment passed the House of Representatives and was followed by the Senate on June 4th, 1919. Then it was submitted to the states. And once that happened, the suffragists mobilized, as you may expect, to lobby state legislatures to approve this amendment, which happened on August 18, 1920, the Tennessee legislature becoming the last of the necessary 36 states at the time to secure ratification. Secretary of State Bainbridge Colby officially announced the adoption of the amendment on August 26, 1920, which was a culmination of decades of movement for votes for women at both the state and national levels. And as we talked about in previous videos, women had limited voting rights as early as the colonial area. But by 1807, they started to be even denied that. In 1848, the Seneca Falls Convention, which I'm sure a lot of people have heard of, adopted the Declaration of Sentiments, which called for equality between the sexes and also included a resolution urging women to fight for their right to vote. Organizations began advocating for the vote using a myriad of different tactics, including legal arguments which used existing amendments already in the Constitution. However, the Supreme Court had to be the jerk and strike all of those down. And once that happened, you had suffrage organizations who were led by folks like Susan B. Anthony, who ended up on the dollar coin for a little while, and Elizabeth Cady Stanton, who called for a constitutional amendment that would guarantee women the right to vote. And now they finally had it. Now, we're at the 20th Amendment, and there's a whole lot in here. So bear with me. We're going to get this straightened out. Let me go ahead and read the text of the amendment, and then we'll get to the explanation. The terms of the President and Vice President shall end at noon on the 20th day of January, and the terms of the Senators and Representatives at noon on the 3rd day of January of the years in which such terms would have ended if this article had not been ratified, and the terms of their successors shall then begin. The Congress shall assemble at least once in every year, and such meeting shall begin at noon on the 3rd day of January, unless they shall by law appoint a different day. If at the time fixed for the beginning of the term of the President-elect shall have died, the Vice President-elect shall become President. If a President shall not have been chosen for the time fixed for the beginning of his term, or if the President-elect shall have failed to qualify, then the Vice President-elect shall act as President until a President shall have qualified. And the President may by law provide for the case wherein neither a President-elect nor a Vice President-elect shall have qualified, declaring who shall then act as President, or the manner in which one is to act shall be selected, and such person shall act accordingly until a President or Vice President shall have qualified. The Congress may by law provide for the case of the death of any of the persons from whom the House of Representatives may choose a President whenever the right of choice shall have devolved upon them, and for the case of the death of any of the persons from whom the Senate may choose a Vice President whenever the right of choice shall have devolved upon them. Sections 1 and 2 shall take effect on the 15th day of October following the ratification of this article. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislatures of 3/4 of the several states within 7 years from the date of its submission. Alright. let's get on to this. 20A basically moved the beginning and ending of the terms of President and Vice President from March 4th to January 20th, and of members of Congress from March the 4th to January 3rd. It also has provisions to determine what is to be done if there is no president-elect, and it was adopted January 23rd, 1933. Basically, 20A was designed to eliminate the lame duck period, or limit the lame duck period, which is the time between election and inauguration, or I won't say inauguration, but of the new government taking office. Indirectly, however, it does require the incoming Congress rather than the outgoing Congress to hold the contingent election in the event no individual wins a majority of the electoral vote in the presidential election. It also establishes the procedures in case that a president-elect dies, is not chosen, or for whatever reason fails to qualify prior to the start of the new presidential term, meaning that a president could be elected, but say his 35th birthday isn't until June the 10th. He can't take office until June the 10th, so you have that. In September of 1788, after the Constitution was ratified, the Congress of the Confederation set March the 4th, 1789 as the date for commencing proceedings of the newly reorganized government. Despite the fact that operations of the government did not begin until April 6th, as a matter of fact, when the House of Representatives chose Frederick Augustus Muhlenberg as the first Speaker of the House and John Langdon as the first President pro tempore of the Senate, and began to count the electoral votes for George Washington. Despite that, March 4th was deemed to be the beginning of the newly elected officials' terms of office, and thus that of their successors. The result of these scheduling decisions was that there was a 4-month lame duck period between election and the inauguration of the new president. For Congress, the situation was even worse. Article 1, Section 4, Clause 2, I believe, mandated a congressional meeting every December after the election, but before the terms of office had expired. Because of that, you had a lame duck session, an extended one, that was required in every even number year. So that meant that new members of Congress, even though they would take office on March the 4th, they might not begin work until more than a year after they'd been elected. And it eventually had the effect of impeding the functions of the government, especially in the 20th century, late 19th, early 20th century. And from the 19th century on, it meant that Congress and the lame duck Congress and the lame duck president could fail to adequately respond to a significant national crisis in a timely manner. And they could do that on the theory that a lame duck Congress or a lame duck presidential administration had neither the time nor the electoral mandate to tackle the problems, whereas the incoming ones did have the time and a fresh electoral mandate, and they were better equipped to handle the problems that were facing the country. And there's two instances where you saw this. Most notably, the first one was in 1861 after Abraham Lincoln was elected. He had to wait 4 months. He and the new Congress had to wait 4 months before they could handle the secession of the southern states. And in 1933, after Roosevelt was elected, he had to wait 4 months before he and the new Congress could deal with the problem of the Great Depression, which was crippling the country. During World War I, as a matter of fact, in 1916, President Woodrow Wilson came up with a pretty odd plan to avoid a lame duck presidency and allow his opponent in 1916, Charles Evans Hughes, to assume the presidential powers immediately in the case that Hughes had won the election. In this plan, Wilson had intended to appoint Hughes as Secretary of State, which was at the time next in line after the Vice President to assume the presidential powers in case of a simultaneous vacancy in the presidency and the vice presidency. And then Wilson and his Vice President Thomas Marshall would have both resigned, and Hughes would have taken over as president, and he would not have had to wait the 4 months for him to be sworn in to have the powers of the presidency. But it was never implemented because Wilson narrowly won re-election. Section 1, we're going to go these by sections here. Section 1 prescribes that at noon on January 20th, the new president and vice president will assume the offices. It shortened the period between Election Day and Inauguration Day by about 6 weeks. It also accelerated the pace of the transfer of presidential powers from the outgoing president to the incoming president. And by changing the date on which the terms begin and end, 20A superseded the 12th Amendment's reference to March 4th as the date by which the House must, if necessary, conduct a contingent presidential election. And also Section 1 specifies that January 3rd at noon was the date for the new Congress to be sworn in. Section 2 moves the yearly start of the congressional sessions from the first Monday in December to noon on January 3rd of the same year. This change eliminated the extended lame duck congressional sessions. And as a result of this, if the Electoral College vote has not resulted in the election of a president or a vice president, the incoming Congress, as opposed to the outgoing Congress, then holds the contingent election. Section 3 further refines the earlier mentioned provisions of the amendment, clarifying that if the president-elect has died before January 20th, then the vice president-elect will be sworn in as the new president on that day. And if there is no definitive choice for president, or if he doesn't qualify by January 20th, then the vice president-elect will serve as acting president until the president is chosen or qualifies. Interestingly enough, on February 15th, 1933, which was 23 days after 20A was adopted, Franklin Delano Roosevelt, who was president-elect at the time, was the target of an assassination attempt. He wasn't hurt, but had it been successful, Vice President-elect John Nance Garner would have become president on March 4th, 1933, in accordance with Section 3. Section 4 empowers Congress to clarify what to do if a contingent election is required by either the House or the Senate and one of the qualifying candidates dies. This has never been done. I don't know why. I think it would be a good idea to handle this, but this is one of the few things that has not been implemented as part of our Constitution. Section 5 delays Sections 1 and 2 from going into effect until October 15th following the amendment's adoption. Because it was adopted on January 23rd, 1933, the terms of the 73rd Congress from 33 to 35 were shortened, and it also resulted in the 73rd Congress not being required to meet until January 3rd, 1934, which means a whole year of no congressional meetings that were required. Also, FDR and Garner's first terms were shortened, and although Garner served 2 full terms as vice president, he did not serve a full 8 years, serving from March 4th, 33 to January 20th of 41. And now we're going to the 21st Amendment, which is a very unique amendment, which we'll get to. The 18th Article of the Amendment to the Constitution of the United States is hereby repealed. The transportation or importation into any state, territory, or possession of the United States for delivery or use therein of intoxicating liquors in violation of the laws thereof is hereby prohibited. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by conventions in the several states as provided in the Constitution within 7 years from the date of the submission hereof to the states by Congress. 21A was proposed on February 20th, 1933, and ratified on December 5th, 33. It is unique among the Constitution's amendments because, for two reasons. It is the only amendment to repeal a prior amendment, and it's also the only amendment where ratification was required by state conventions. And the text of the amendment is pretty much self-explanatory. I mean, it just repeals the 18th Amendment, and it allows transportation, sale, and distribution of intoxicating liquors, as long as it does not violate state laws. Now, the 22nd Amendment is another biggie. We're going to get to that. There's a lot in it, so like I said, bear with me. No person shall be elected to the office of president more than twice, and no person who has held the office of president or acted as president for more than 2 years of a term to which some other person was elected president shall be elected to the office of president more than once. But this article shall not apply to any person holding the office of president when this article was proposed by Congress, and shall not prevent any person who may be holding the office of president or acting as president during the term within which this article becomes operative from holding the office of president or acting as president during the remainder of such term. This article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by the legislatures of 3/4 of the several states within 7 years from the date of its submission to the states by Congress. 22A basically limits the terms of the president of the United States and sets additional conditions on presidents who succeed to unexpired terms. Prior to this, presidents had not been subject to term limits at all, but George Washington had established the two-term tradition, which most presidents had followed, and there were some presidents who felt that the president should not serve more than one term. However, in 1940, FDR became the first president to win a third term and later a fourth one in 1944, which made people start to be concerned about the potential issues with someone serving an unlimited number of terms, especially since FDR died in office. Congress approved 22A on March 24th, 1947, and it was ratified on February 27th, 1951. 22A limits an individual to being elected to the presidency only twice. If an individual has served more than 2 years of an unexpired term, that person can only be elected one time, thereby making the maximum number of years one person can serve as president as 10. It did not apply to Harry Truman, as he was the incumbent president at the time. Truman had served nearly all of FDR's fourth term, and then was elected to his own term in 1948. Although he was eligible to seek re-election in 1952, his approval ratings were really low, and he did very poorly in the New Hampshire primary in 1952. So he chose not to seek the nomination of the Democratic Party for that year. Since becoming part of the Constitution, 22A has applied to 6 presidents who have been elected twice: Dwight Eisenhower, Richard Nixon, Ronald Reagan, Bill Clinton, George W. Bush, and Barack Obama. 2 other presidents since 51 have been impacted by 22A. Lyndon Johnson, as we all know, became president on November 22nd, 63, following the assassination of John F. Kennedy. And he served the remaining 14 months of Kennedy's unexpired term. Johnson was later elected to a full term of his own in 1964, and 4 years later in 68 he briefly ran for a second full term, which he was allowed to, but he withdrew during the primaries. Had he served a second full term, the total length of his presidency would have been 9 years and 59 days. And consequently, Johnson died on January 22nd, 1973, 2 days after his term would have ended had he served a full second term. In contrast, though, Gerald Ford, who served the remaining 2 years and 164 days of Nixon's unexpired second term, was eligible for only one full term, which he sought in 1976, but was subsequently defeated. There have been many efforts to repeal 22A over the last 60 years, even as recently as President Bill Clinton stating that, taking into consideration longer life expectancy that we have today, maybe 22A should be modified to limit presidents to 2 consecutive terms. I guess old Billy Boy got drunk with power while he was in there. I know Obama did, and several other guys, as a matter of fact. But I don't know. It's a catch-22. I mean, should we repeal 22A? Should we modify it to say that presidents can serve only 2 consecutive terms? You know, who's to say? I mean, it's a discussion that should be taken up. I mean, but I think that what needs to be done is need to get a little bit better control over our government, and make sure that things are being done the way they need to be done before we start talking about having somebody serve as president for more than 2 terms. Now, the 23rd Amendment gets more into voting rights. The district constituting the seat of government of the United States shall appoint in such manner as the Congress may direct a number of electors for president and vice president equal to the whole number of senators and representatives in Congress to which the district would be entitled if it were a state, but in no event more than the least populous state. They shall be in addition to those appointed by the states, but they shall be considered for the purpose of the election of the president and vice president to be electors appointed by a state, and they shall meet in the district and perform such duties as provided by the 12th article of amendment. And Congress shall have the power to enforce this article by appropriate legislation. Okay. The Constitution's rules for the composition of the House and Senate explicitly grant seats to the states and no other entities. In the same vein, members of the Electoral College are appointed and apportioned also to the states and not to the territories or to the federal district. However, it says in Article 1, Section 8, Congress is granted direct legislative power over D.C. And while it was perceived in 1961, when the amendment was passed, while D.C. was perceived as politically neutral and only somewhat liberal-leaning at the time, D.C. has swung dramatically left in the years after passage. D.C. has sent 3 delegates to the Electoral College, and every single presidential election year, D.C. has voted Democratic since 1964, including in the 1984 landslide re-election of Ronald Reagan. Yeah, in '84, Reagan carried every state except Minnesota and D.C. 525 to 13. That says something. But that basically gives the people of the District of Columbia the right to vote for president and to appoint members of the Electoral College. However, D.C. can choose their electors in whatever manner they want, just as the Constitution allows for the states. 24th Amendment. The right of citizens of the United States to vote in any primary or other elections for president or vice president, for electors for president or vice president, or for senator or representative in Congress, shall not be denied or abridged by the United States or any state by reason of failure to pay any poll tax or any other tax. The Congress shall have the power to enforce this article by appropriate legislation. 24A prohibits both Congress and the states from conditioning voting rights in federal elections on the basis of poll taxes or any other tax. It was proposed on August 27, 62 and ratified by the states on January 23, 64. Following the War for Southern Independence, some of the former Confederate states adopted poll taxes in laws of the late 19th century and in new constitutions of their states from 1890 to 1908, after the Democratic Party had generally regained control of the state legislatures decades after the end of Reconstruction. And this was a measure to prevent African Americans and poor whites from voting. The use of poll taxes by the states was held to be constitutional by the Supreme Court in the 1937 case Breedlove versus Suttles. When 24A was ratified in 64, 5 states still retained a poll tax. They were Alabama, Arkansas, Mississippi, Virginia, and Texas. The amendment prohibited requiring a poll tax for voters in federal elections, but in 1966 the Supreme Court ruled 6-3 in Harper versus the Virginia Board of Elections that poll taxes for any level of elections were unconstitutional. It was said that these violated the Equal Protection Clause of the 14th Amendment. And today, most people who are opponents of laws requiring photographic identification to vote are claiming that these laws are a violation of 24A, even though every state that has passed such a law has a type of identification accepted that can be obtained under no cost. Now, the 25th Amendment is another important one requiring talking about presidential succession. It was proposed July 6, 1965 and ratified February 10, 1967, and it has been used several times. So we're gonna discuss this. Let me get to the text of it. We're gonna do it section by section, like we did in the other articles of the Constitution. Section 1. In case of the removal of the President from office or of his death or resignation, the Vice President shall become President. This clarifies that in any situation where the President is gone from office, the Vice President will become the President instead of merely assuming the powers and duties of the presidency. Section 2. Whenever there is a vacancy in the office of the Vice President, the President shall nominate a Vice President who shall take office upon confirmation by a majority vote of both houses of Congress. This section addresses the Constitution's original failure to provide a mechanism to fill a vacancy in the Vice Presidency. And quite a number of times the Vice Presidency had become vacant due to many extenuating circumstances. Let's see. You had George Clinton, who died in 1812. Elbridge Gerry, who died in 1814. John C. Calhoun resigned the vice presidency in 1832. You had John Tyler, who became president in 1841. You had Millard Fillmore, who became president in 1850. William King died in office not long after his term began in 1853. Andrew Johnson became president in 1865. Henry Wilson died in office in 1875. Chester Arthur became president in 1881. Thomas Hendricks died in 1885. Garrett Hobart died in 1899. Teddy Roosevelt became president in 1901. James Sherman died in 1912. Calvin Coolidge became president in 1923. Truman became president in 1945. Lyndon Johnson became president in 1963. You had Spiro Agnew, who resigned in 1973, and Gerald Ford, who became president in 1974. Now, we'll get to the last two here in just a second. Section 3 says that whenever the President transmits to the President pro tempore of the Senate and the Speaker of the House of Representatives his written declaration that he is unable to discharge the powers and duties of his office, and until he transmits to them a written declaration to the contrary, such powers and duties shall be discharged by the Vice President as acting President. This section allows the president to voluntarily transfer his powers and authority to the vice president by declaring in writing his inability to discharge his duties. And that's been done a couple of times. The vice president then assumes the powers and duties of the presidency as acting president. The vice president does not become president, and the president stays in office, although without his authority. He regains his powers and duties when he declares in writing that he is again capable of discharging them. Now, Section 4 is important. I think it's to some extent a bad idea, but we'll discuss that in a minute. Whenever the vice president and a majority of either the principal officers of the executive departments or of such other body as Congress may by law provide transmit to the President pro tempore of the Senate and the Speaker of the House of Representatives their written declaration that the President is unable to discharge the powers and duties of his office, the Vice President shall immediately assume the powers and duties of the office as acting President. Thereafter, when the President transmits to the President pro tempore of the Senate and the Speaker of the House of Representatives his written declaration that no inability exists, he shall resume the powers and duties of his office unless the Vice President and a majority of either the principal officers of the executive departments or of such other body as Congress may by law provide transmit within 4 days to the President pro tempore of the Senate and the Speaker of the House of Representatives their written declaration that the President is indeed unable to discharge the powers and duties of his office. Thereupon, Congress shall decide the issue, assembling within 48 hours for that purpose, if not in session. If the Congress within 21 days after the receipt of the latter written declaration, or if Congress is not in session within 21 days after it is required to assemble, determines by 2/3 vote of both houses that the President is unable to discharge the powers and duties of his office, the Vice President shall continue to discharge the same as acting President. Otherwise, the President shall resume the powers and duties of his office. This section addresses a case of an incapacitated president who is unable or unwilling to invoke Section 3. And this is 25A's only provision that has never been used. It allows the Vice President and a majority of the Cabinet Secretaries to declare the President unable in a written declaration. In that instance, immediately the Vice President will become acting President and not President. The President remains in office but without any authority. A President who is declared unable to serve may then issue a counter declaration. However, the Vice President must remain acting President for 4 days. If by the end of that 4 days, the Vice President and a majority of the Cabinet Secretaries have not issued a second declaration, then the President will resume his powers. If the second declaration of incapacity is issued within the 4 days, the Vice President remains acting President while Congress decides the issue. If within 21 days both houses determine by a supermajority vote that the President is unable to discharge his office, then the Vice President remains acting President, otherwise the President resumes his powers. Section 4 is very problematic in that there is the possibility to circumvent the impeachment process and effectively remove a president from power, and in my opinion, tantamount to treason. The 25A has been invoked several times since it came into force. On October 10th, 1973, Vice President Spiro Agnew resigned amid scandal. And 2 days later, President Richard Nixon appointed Gerald Ford to replace Agnew as Vice President. The Senate voted 92-3 to confirm him on November 27th, and the House voted 387-35 to confirm Ford on December 6th. He was then sworn in later that day before a joint session of Congress. When Nixon resigned as president on August 9th, 1974, Ford became president. Once again, the vice presidency was vacant, and Ford nominated Nelson Rockefeller on August 20th. The Senate confirmed him on December 10th, 74, by a 90-7 vote, and the House confirmed him by a 287 to 128 vote on December 19th of 1974. Rockefeller was then sworn in later that day in the Senate chamber. On July 12th, 1985, President Ronald Reagan underwent a colonoscopy, during which a precancerous lesion was discovered. Reagan went ahead and elected to have it removed right away. And after consulting with White House counsel, Reagan chose to invoke Section 3 of 25A. On July 13th, Reagan transferred power to Vice President George H.W. Bush from 11:28 a.m. until 7:22 p.m. On June 29, 2002 and July 21, 2007, President George W. Bush underwent colonoscopies as well and invoked Section 3. For approximately 2.5 hours each time, Vice President Dick Cheney was transferred into the powers of the presidency. Section 4 has been considered a few times. The first one following the 1981 assassination attempt on Ronald Reagan. Vice President Bush did not assume the powers as acting president. Reagan had been rushed into surgery with no chance to invoke Section 3, and Bush did not invoke Section 4 because he was in mid-flight at the time of the shooting, and by the time he landed in Washington, Reagan was out of surgery. In 1987, upon becoming White House Chief of Staff, Howard Baker was advised by several staff members to prepare for a possible invocation of Section 4 due to Reagan's perceived ineptitude. Reagan dispelled all these concerns when he arrived for the first meeting with Baker, alert, coherent, and full of energy. Most recently, President Donald Trump fired FBI Director James Comey in May of 2017. Acting FBI Director Andrew McCabe held high-level Justice Department discussions about approaching Vice President Pence about possibly invoking Section 4. Nobody knows if any of Trump's cabinet members were approached with this. On March 15th of 2019, Senator Lindsey Graham announced that the Judiciary Committee of the Senate would investigate the matter. Honestly, that's a pile of shit. I see no inability. I see no ineptitude. The guy is perfectly lucid. He knows what he's doing. He's inexperienced as a politician, but I think that's what we need. I think people are just pissed off because things are getting done for the first time in a long damn time. Now, the last two amendments are very short, and we're going to cut this down in under an hour, I believe, if I can do this. This is amazing. We did 11 amendments in under an hour. The 26th Amendment: the right of citizens of the United States who are 18 years of age or older to vote shall not be denied or abridged by the United States or any state on account of age. The Congress shall have the power to enforce this article by appropriate legislation. Self-explanatory. It was proposed by Congress March 23rd, 71, and ratified on July 1st of 71. The fastest ratification of any amendment in history. And the 27th Amendment, one a lot of people don't know about: no law varying the compensation for the services of the senators and representatives shall take effect until an election of representatives shall have intervened. This amendment was part of the original 12 that was submitted in the group in 1789, and the last 10 of them became the Bill of Rights. It was submitted September 25th, 1789, and pretty much largely forgotten about until 1982, when a college student wrote a paper claiming it was still able to be ratified. And he set about ensuring the amendment was ratified, which occurred on May 5th, 1992. it puts a limit on raising congressional pay until after an election has been completed. Theoretically, Congress members could be raising the pay of their successors. So, and that's something else we need to discuss. But there you have it, ladies and gentlemen. There's the United States Constitution, all 7 articles, all 27 amendments. Any questions, comments, debate? I welcome it all. Civilly debate. I have no time for derogatory crap. If you have a dissenting opinion, I'd love to hear it. But I charge you to please come prepared with facts, not passions, facts. Because President John Adams, to paraphrase him, he said that regardless of our passions, the facts remain indisputable. And I'm going to bid you all a farewell, a happy weekend, and my next video, I'm not sure when it will be, but we're going to have more related topics. I may talk about, I'm thinking about talking about the causes that led to the what is known as the Civil War, but is in reality the War for Southern Independence, and I'll discuss that later. I think that will be my next video, and then another video is going to be on other topics related to our government and how things work. So until I see you guys again, peace.